Well, tomorrow morning at the International Court of Justice at The Hague, lawyers representing our country will argue Israel is guilty of genocide or proposed genocide for the way it's behaving in Gaza. As you know, at least 22,000 Palestinians, probably more, have been killed through Israel's actions in Gaza. Its attacks have left most of the population homeless, and hundreds of thousands of people have been forced into the south of the enclave. Several Israeli politicians have also proposed that Gaza be depopulated. In other words, Palestinians would be forced out of Gaza permanently, perhaps into the Sinai Desert in Egypt. All of this is a response to the attacks by Hamas on Israel, in which 1,200 people were killed and around 200 Israelis were taken hostage by Hamas. Professor Thomashausen is an emeritus professor of international law, at Unisa. Professor, good afternoon to you and thank you for your time. I've seen several legal commentators tell us on Newsfeed over the last couple of days that South Africa is a strong case, that our lawyers will be able to make the case that Israel is committing genocide or potential genocide in Gaza. Do you agree with those commentators? Do you believe we will be able to make that case?
Well, good afternoon, viewers. I'm a little bit more cautious, and all this in advance shoulder clapping and bravado, it doesn't really make up for deficiencies in the application. The application, with its 84 pages, dedicates only about 7 pages to the actual legal argument, and it overlooks case law. And something like the ICJ, the International Court of Justice, also known as the World Court, works totally on custom, state practice, and precedents, its own decisions. And vital is the decision of the ICJ in the case of Croatia against Serbia in 2015, where the ICJ stated very, very clearly, referring back to a judgment on Bosnia versus Serbia in 2007, stated, for a pattern of conduct to be accepted as evidence of the existence of a genocidal intent, it would have to be such that it could only point to the existence of such an intent. That means the only inference that could reasonably be drawn from the acts of Israel would have to be a genocidal intent. And I don't see that before me. I don't see that in the 75 odd pages of references to newspaper reports that South Africa intends to put before the court. So what this is really about is to try and convince the court to adopt some interim measures, knowing that a decision on the merits will take 3 to 4 years in the practice of the ICJ. So it's not really about the merits, it's about getting interim measures into place.
So are you suggesting then that the legal definition of genocide that the court would have to look at is actually a very narrow definition, and we're sort of making too broad an argument?
Absolutely a narrow definition. The convention, the Genocide Convention, comes about in 1948 as a reaction to what happened during the Holocaust and World War II in Germany, where there was a declared and specific policy: we will build railway tracks, we will build huge infrastructure to destroy, to eliminate the Jewish people as such. So that is where the Genocide Convention comes from, and indeed, unfortunately, in human history, such things occur very, very rarely and seldomly. Not every war crime is an act of genocide. But I think the lawyers that put this together, they knew this very, very well. It isn't really about winning a judgment condemning Israel of the crime of genocide. It is about getting interim measures into place, getting the World Court to say all use of force in Gaza must now stop. And that would mean that allies of Israel would be prevented or would be acting illegally if they still support Israel militarily. So it would seriously frustrate Israel's self-defense operations.
So, Professor Thomashausen, just to extend what you say there a little bit, are you suggesting that this is really all about putting pressure on the United States to stop arming Israel?
That is really what it's about, although many cynical observers here in South Africa and, of course, elsewhere are saying what it's really about is the vote of 500,000 Muslims in South Africa that the ANC has to secure for the forthcoming elections. But that is a bit of a polemic argument. So let us stick to the application. The application wants they want to stop what is happening, and they want to make it very difficult for any allies, most European countries and the US, to keep on, for instance, sending ammunition and military hardware to Israel, which of course would expose Israel further to the existential threat that they are faced with for a long time already. Iran, Hamas, and many others have been proclaiming that Israel as a state should not exist. Israel as a state should be cancelled. And that goes against the most fundamental norm of international law, where the equal sovereignty of all states is guaranteed. Nobody is allowed to deny another country its right to exist and its right to sovereignty. Let us hope that the ICJ will find a way to possibly arrive at an agreed set of interim measures between the parties, South Africa and Israel, and that would have to involve the hostages. There are still 138 hostages, which the International Court cannot simply abandon. They cannot simply pretend that they don't exist. They have to be concerned with their lives. So obviously the outcome then might be that Israel is ordered to stop the use of force in Gaza if and once the 138 hostages are released.
Professor, the argument that Israel, I presume, will make, I haven't seen their arguments, you might have, but they're likely to make that Hamas and Iran have said that Israel doesn't have a right to exist, and there's this phrase, it's a very controversial phrase, from the river to the sea, which effectively means that would be the territory of Palestine and Israel would no longer exist. But doesn't that go both ways? If it's wrong, if Israel's allowed to defend itself against being removed from the face of the earth, surely Palestinians in Gaza have the right to do the same thing. And the argument would go, but isn't Israel, by trying to remove people from Gaza, and certainly from the north of Gaza, trying to remove Palestine, trying to remove people from Palestine, trying to remove them, or trying to remove Gaza from the face of the earth, and that must be wrong too.
Well, that is certainly what the pro-Hamas lobby in the world, and it is backed by a very large number of people of Islamic faith in the world, maybe 1 billion, that is the point they are making. Except Israel will defend and will say, we never had any intention of doing anything to the Palestine people as such. Our aggressive statements were aimed at Hamas, and it is clear from the context within which they were made. You can't just take one phrase out of a context. If one or the other hothead or one or the other private person made extremist remarks that cannot be attributed to the government, and the Israeli Defense Force did everything they could to spare non-combatant lives. They claim that they have by now destroyed 9,000 Hamas combatants, which would mean that the civilian collateral victims are more or less 1 to 2. And they will argue that that is very proportional. That is one of the best and the least damaging war efforts in modern times when you compare it to what happened in Syria, when you compare it to what happened in Iraq with 1 million dead civilians. Now in Sudan, also approaching 1 million, the death toll. And of course in Yemen, also close to 1 million, maybe more. Some people argue it's even 2 million in Yemen and Ukraine. Nobody denies now that Ukraine has lost 500,000 people, and Russia has probably lost close to 100,000. So Israel will argue, we were very careful. We really minimized the civilian casualties. Yes, it is terrible that there are thousands of civilian casualties, but in a war situation where we're acting in self-defense, we warned everybody. We asked people to remove themselves from certain areas where we knew that we had to destroy Hamas infrastructure and tunnels, and we acted responsibly. That will be their defense. Let us see how the 15+2 judges will query this, what kind of evidence they will ask to see. But my guess is there will be an attempt at arriving at interim measures that happen by agreement of both sides, because then it is also assured that they will be complied with if Israel agrees to a certain degree with interim measures.
Well, compliance is also one of the big issues, of course. Professor, I'm glad I'm not a lawyer who has to argue that killing 22,000 people is okay, but I realize these things happen in the world. I do want to ask you one other question, if I may, which is I've seen, and maybe it's just the WhatsApp groups that I'm on, but I think, many people will have seen the arguments that our lawyers are going to bring tomorrow. I have not seen the Israeli arguments. I presume they would have to, like you do in a criminal case, in a civil case here, you would give we call them heads of argument in our system. You would have to give those to the judges. Is Israel making its arguments publicly available? Is there anything to gain by only giving the arguments in court once the proceedings start?
Well, there are some very fundamental papers by their top legal experts, but an actual heads of argument are not required in the ICJ. This is an oral procedure, and you present your arguments to the judges during the trial. So we don't know those. We can only understand that obviously Israel's defense will be there is no evidence of a genocidal intent, and consequently the entire accusation of a crime of genocide is without basis, and consequently there are even no grounds to order interim measures. So that will be in a way, an extreme position. And they will, of course, insist and clarify and prove and put before the court that the attack on the 7th of October, where way over 1,000 people were gruesomely butchered, literally butchered, people's limbs were broken before they were killed and things like that, that is a sufficient ground to exercise the right to self-defense, and that this right to self-defense was exercised reasonably. But as I say, because compliance is always an issue when the ICJ is concerned, let us hope that the parties can agree before the court to undertake to do certain things, to release the hostages, to stop the use of force, to make a concerted effort at helping the dislodged people, the people that have lost their homes, that have lost their infrastructure, and that we can come back to some rationality in this conflict, which will then, in the course of the year, with the help of the neighboring countries, will have to involve finding solutions. It is remarkable that even yesterday, Saudi Arabia agreed to exchange ambassadors with Israel. So Saudi Arabia, for instance, who had very much a hand in supporting Hamas at its onset, at its origins, Saudi Arabia is certainly not of the opinion that isolating Israel, that demonizing Israel would be a good start to find peace in the region.
Professor Thomashausen, really appreciate the time. Thank you very much indeed.